So welcome everybody to the Sailfish chapter of the FICPA's presentation of Chapter 11, Subchapter 5, Rules, Bankruptcy Rules to Save a Business. If you all wouldn't mind muting yourselves during the presentation, we will have questions. We'll have plenty of time for questions after. You can also post some questions in the chat, and I will print that and make sure we address all of those. We also have a few slides for today's presentation. If you want to contact me or just post your email in the chat, I'd be happy to send those to you. All right, so I'm going to introduce our speakers today in the order of our title page here. We have John Martin, who is a local attorney. He's got a BA from Capital University, magna cum laude in international relations with a minor in economics and political science, a JD from the University of Cincinnati, and an MBA from the University of Cincinnati. In addition to admission to the Supreme Court of the United States of America, he is admitted to practice throughout the state of Florida, as well as the Southern and Middle Districts of the Federal Bankruptcy Bar in Florida. He's also served as the chairman of Martin County Bar Bankruptcy Committee from 2005 through current, and received the Pro Bono Publico Award for his efforts in conducting pro se bankruptcy classes for the Southern District of Florida Bankruptcy Program. He's a member of a slew of bankruptcy related and legal committees as well. Welcome, John. We also have Bill West here. Bill began helping Florida entrepreneurs focus their business and obtain financing in 1992. As a commercial lending executive, he went on to lead his bank's workout teams through the Great Recession before becoming the regional credit director for the second largest independent bank in Florida. He is a Marine Corps veteran and was awarded the McLaughlin Award by the Florida Economic Development Council for his leadership in emergency lending. Welcome, Bill. And last but not least, we have Tarek Kiem, attorney and managing member of Kiem Law PLLC. He is an attorney and also a fellow CPA, as well as MBA holder. He is the Subchapter V trustee for the Southern District of Florida. He's a solo attorney here in South Florida, where he's devoted over 90% of his legal practice to the area of bankruptcy for the last 15 years. He started off his bankruptcy journey by clerking for bankruptcy judge Raymond B. Ray, and then he joined a few other boutique firms here in South Florida. And in 2017, he started his own firm in Lake Worth. And in February 2020, he was appointed as a Small Business Chapter 11, Subchapter 5 trustee in the Southern District of Florida under the Small Business Reorganization Act of 2019. Prior to focusing on bankruptcy, Tarek also worked as an auditor and international tax advisor for Deloitte. So welcome everyone. Very excited to hear your presentation today, and I'm going to mute myself and turn it over to Bill.
Excellent. Thank you, Mary.
One of you.
Thank you all. We are excited to be here for the FICPA, for this presentation to the FICPA. Just want to share a couple things here with you. So Mary, my introduction, I didn't even realize until she kind of read it there. It's what brings me here today. It's my work in banking and my work in economic development that really piqued my curiosity. John and Tarek worked on a case, and John started describing this case to me, and I was just like, wow, being a former workout officer, being a banker, when you tried to work with people as best you could, you got them down a path. But when you heard the bankruptcy word in small business lending, anyhow, you became very, very concerned. It was very likely to be a liquidation. People were going to be out of work. People were going to be out of business. It wasn't a good scene. So John began describing this Subchapter 5 ruling to me, began describing what he was working on with this case. And I thought it was incredibly intriguing, started digging into it a lot. And this is what I've kind of narrowed it down to. These are the real key pieces. This is what has changed. And the playing field really changed here with this Subchapter 5, with these new Subchapter 5 rules for small businesses. The cram down. So the debtor has a lot of control over the plan. The debtor really is in control of the bankruptcy now, and can drive that action on the bankruptcy. There's no absolute priority rule. That's where the borrowers, the debtors, always, they lost their equity before. You had to repay all of the unsecured creditors in order to retain your equity, and you don't have to do that anymore. And then the cost and the speed of these transactions. So it's something that's going to happen very, very quickly. As you'll hear, this case, I think I started hearing it. It was less than a year ago, I'm certain, that I started hearing about it. And within, I think, 6, certainly 9 months, it was a closed, confirmed case. And we'll start from here. I've got one more slide I want to share because I want you to be thinking about, if it'll change the screen for me, what's your opportunities here? So you're looking at this from accounting professionals, from a CPA perspective. What is there for you? And the biggest thing, everybody, it's retaining the client. So you're going to keep an ongoing client. They're going to be in business, and they're going to be incredibly happy with you because the end result is they are still in business. What else is there? The debtors need current financials. They need current tax returns. They can't proceed with what they have to do. The attorneys can't proceed with what they have to do without that. So you're going to have to get that debtor current. Fractional services, and there's financial advisors, forecasting, potential chief restructuring officer, but it has to be very light. As you'll learn from this discussion today, it's there's not a lot of room. As I said, the cost is one of the biggest drivers in here. So we're keeping the cost down. Everybody's keeping the cost down purposefully through this transaction. And then the post bankruptcy budget preparation, projection verification. I guess I said that in my forecasting comments there. So that is really it. From here, Tarek's going to give you an overview of what's been happening on the Subchapter 5 level since kind of COVID. These changes really occurred right as COVID was kind of coming around. I think it kind of got buried. People don't know about it. So this is going to be a tool that'll be out there as businesses. We're starting to see more and more of them trip up as we're running out of government funding here. As you start to see more of this will become a bigger tool. But with that, I'm going to turn it over and stop sharing. And Tarek, it is, if I can, your turn.
Great. All right. All right. So just to give you an overview of Subchapter 5, it's a recent law. It's just over a year. And, you know, I like to call it the express lane of Chapter 11, you know, where it's a lot faster than the regular 11 track. You know, you have a plan proposed in 90 days. You have a major status conference within 60 days. And normally, you know, debtors are in and out, you know, I would say within 6 months. The whole idea of Sub 5 is not only to expedite the process, but to minimize the costs to the debtors, accelerate the return to the creditors, with the assistance of an appointed Subchapter 5 trustee. You have about 6 Sub 5 trustees in the Southern District of Florida, and the main goal is to reach a consensual plan. And the idea is the shorter the shorter time the debtor is in bankruptcy, the lower the cost will be. So, you know, that's the primary purpose of Subchapter 5. Eligibility, pretty much anybody, you know, where 50% of the debt is for commercial or business activity would qualify for a Sub 5 currently. With the COVID relief bills, you know, the debt limit was increased to 7.5. That expires in sometime this month, and I'm being told that it's going to be extended. I haven't yet seen an extension, but apparently it's going to be one of these relief bills coming down the pipeline fairly soon. Sub 5 eligibility doesn't include real estate debtors or single asset real estate debtors, but you know, pretty much anybody who's incurred most of their debt regarding business, you know, whether it's a guarantor or something else, you know, would qualify for Subchapter 5. it's a recent law, so we don't really have a lot of sub fives in Florida. You know, this is just statistical information for the entire U.S. and there isn't yet. They haven't yet started to track the sub 5 cases, so this is just an estimation of how many sub 5 cases, you know, we have in the Southern District of Florida. So right now, of the approximately, you know, 1,400 cases, it's about 400 in Florida, and then about approximately 400 in South Florida, and approximately, actually, I'm sorry, 40 in South Florida, and approximately 15 of them I'm the sub 5 trustee on. Let's see. Basically, my responsibility as the trustee is to work with everybody on a consensual plan. And part of doing that is evaluating the viability of the business and the prospects for reorganization. So what I look at is I look at the financials of the debtor, look at the balance sheet, the income statement, you know, tax returns. Normally that's a pretty independent document. They can look at and get a flavor for the debtor's operations and to figure out if there's something worth reorganizing. You know, usually the process that I use is, you know, I try to encourage the debtors. They spent the money to hire an attorney. So I encourage the debtors, you know, to come up with their best plan, communicate with the crucial creditors. The creditors are giving them issues to see what they're looking for in a reorganization plan. And then, you know, through the amendment of the plan process, you know, try to reach some kind of consensus and consent. And that's just pretty much it with regards to the mechanics of the Subchapter 5 process.
Excellent. And I didn't set up John to follow up here. So now John is going to kind of give us a briefing and overview of this case, so the trucking company that they worked on, but that's about as much as I'm going to say about it. I'm going to let John pick it up from here.
Okay, I think I'm unmuted now. And I'm on let's talk about where we started from when the clients first came in the office. This was a family-owned over-the-road trucking business. They had reached a good degree of success and size. However, because of a collapse in the flatbed market, if you want to call it that, they had lost major revenue because of the hyper competitiveness in that particular segment. So they had overwhelming debt service that couldn't be maintained under their current structure and their current income. They had extended themselves personally, and business credit lines both all were exhausted. They'd done everything to try to keep the company afloat, keep it going, and in fact, when they first came in, they were coming in to talk to me about personal bankruptcy because they didn't see a possible way to survive with the business. At that point, they had been factoring receivables just to stay afloat, just to keep money rolling in as fast as possible, to keep tires on the trucks, service and maintenance that needed to be done, and that sort of thing. They had unused equipment sitting on the side, paying lot storage on it because they couldn't maintain the equipment. It was older and high cost to operate. As I said, they came in with expectations they were going to have to close the business. The one thing they did have going for them, however, was they had preferred provider status with their one major account. And that really weighed heavily in what we were going to next. So we look at what happened after we got them through the bankruptcy. Under this new sub 5, they of course fell under the $7.5 million debt rule. In fact, they fell under the 2.7. But what we did was we took a good look at where they were at, what they needed to continue operating. And we surrendered any unprofitable equipment or equipment that could not perform, couldn't generate revenue. That eliminated some of the secured debt, leaving whatever was going to be unsecured out after they had liquidated that. We reduced secured liens by about $477,000 on 4 of the big tractors. That's the tractors that pull the trailers, the big trucks. We settled UCC1 claims at 25%, which made another reduction of about $145,000 in debt service that they were going to have to handle. We cut debt service approximately $7,000 per month. The unsecured payout at the end of the day works out under the current figures at about 7.35% over 4.5 years. We spread the payment out, which provided a little bit better of a payout to the unsecured creditors. It made a total debt reduction on that line of $693,000. What was the good upshot of it? Owners retained their livelihoods and were able to continue operating their business. 15 employees were able to retain their jobs and support their families. We were able to establish a reserve account for maintenance and repairs going forward so that they wouldn't run into a cash flow problem just because of emergencies break down. The big over-the-road trucks, when something goes wrong, it's not cheap. It's not a few $100, it's always thousands. They're positioned now for growth and positive cash flow. Results are something that I think Congress had in mind. And I think Tarek made mention that he wasn't sure what the status was on renewal, but I do know that on February the 25th, Senators Durbin and Grassley co-sponsored a bipartisan legislation, and it's been read twice. It's whether they'll make the deadline for the 27th or not, I think still remains to be seen. But it's a very good process for small business owners. It can save, at one point they talked about expanding it to 10 million, not just 7.5 million. And I believe it was estimated at that point, if they got to that, it would enable about 90% of all small businesses in America to utilize this process. What it does, as you can see, it saves the jobs. It provides at least some payout. It shapes debt in a fashion that allows the company to continue operating. And we had a confirmed plan. So that means we're setting in good shape so that if the economy should take a sudden super dive beyond where we're already at, they're already in the clear. They don't, I mean, we will file an amended plan, but they've already got their confirmation and problems are out of the way. I had some other slides that I'll just go through quickly. The idea is before you file a case, you have to really know a lot about your company, your business, and the people that own it. You got to see where their debt service is at, overhead. You're looking at all of the things that are necessary, leases and contracts that can be rejected, necessary or advantageous trade creditors that you want to keep and have to deal with. That's part of what Tarek was talking about. You have to negotiate with your creditors. As I pointed out, we managed to negotiate a number of our creditors, UCC1 filers, to a 25% payout. Very, very good result for that. As I said, we surrendered some equipment and we appraised and actually crammed down some of the newer trucking equipment to reduce debt service. We obviously looked at what was going to happen with personal liability because most small businesses, they have to personally guarantee monies that they borrow. And so that puts them on the hook as well. And you have to develop an overall plan for both the owners and for the company. You review sources of capital. Is there Uncle Bill out there somewhere that can help bring some money to the table? We look at their history and experience, and again, other resources. We're concerned with the status of the IRS. That's where the CPAs and the accountants come on board, and we have to have up-to-date information for the trustees. In regards to that, We get appraisals on the equipment so we can do whatever cram downs are possible. Obviously, we are negotiating from day one. It just has to be. And we do multiple cash flow projections to get where we want to go. We do the same thing, really. It takes time to get it together, and then we don't just file it. We have to go back to the owner for a final look, make sure that they're in agreement with everything that we're doing and what their total plan is. When we do get filed, the automatic stay takes effect immediately. The trustee is appointed. In this case, it was Tarek, Kiem, and discussions on background and objectives begin with the trustee, because I'm looking for the trustee sort of in a partner, almost a partnership type of affair. We're both trying to get this company salvaged if it's possible. We're trying to make it float, keep the jobs, keep the livelihoods going for the people that own the company and the livelihoods for the people that work in the company. Timelines and approximate schedules get discussed and worked out. And the real key is Subchapter 5, all parties, and I mean all parties, including debtors, creditors, trustee, attorneys, all work towards confirmation, because there's no alternative. No alternative. The rule is you're either going to get an agreeable confirmation, or you're going to get a contested confirmation. But at the end of the day, the creditors don't make that decision. The court does, and as long as the court sees a fair and equitable arrangement that they can endorse, you're going to get the confirmation. So that's pretty much mine. I'm going to back out of here a minute and put it back to Mary or Bill or whoever wants, if there's questions, perhaps.
Let's talk about this case a little bit, John. So it was a trucking company. You said there were 15 employees at the time. How did you kind of make you kind of mentioned the over the road? Tell the story about the over the road a little bit and what kind of happened there, and then let's introduce it into Tarek here and how you guys started cooperating towards that goal.
Well, as I said, they first came in all heads down, and it was a very grim outlook as far as they were concerned. It took a little bit of talking. I probably had about an hour and a half in the first interview, because I could tell right off the bat when they talked to me about their preferred status, preferred provider status. I thought, well, maybe. So you ask an awful lot of questions. Well, why have you got so much debt? Well, we had to refinance. And you see a lot of things. For instance, the brokering of the accounts. They were losing 15 to 20% alone. I just told them, I says, well, whatever you do, quit doing that.
Sure.
If you have to delay paying somebody else, you're losing income left and right just by doing that. It's not really going to preserve. It's not going to save your company. What's going to save your company is restructure.
So you got a hold. You were interviewing them. You see these excess expenses, the factoring expense. Obviously, you can eliminate. There's extra trucks that have specific debt associated with them, and you can eliminate that, and you kind of start to frame a plan.
Right. That's referred to as being surrendering certain items that have secured loans on them. We appraised 4 of the newest trucks. They were the big heavy duty Max, computerized, just amazing vehicles. I went out during the appraisal to take a look at them. They're amazing vehicles, what today's modern trucks do. But we had them appraised. Like I said, we chopped about nearly $500,000, as I remember, off of the debt on those trucks. But the reason that debt was there is because somebody had stuck additional monies for where they traded in a truck. And they said, well, your truck isn't worth that much, so we're going to add this much to the debt. Well, that was, it's typical used car type of finance business, but it wasn't doing them any favors at all, A lot
bigger numbers.
Sorry?
It's typical car finance business, but a lot bigger numbers they were working with.
Lots bigger numbers.
So you had this plan, you kind of created this plan, and then Tarek, you said you saw something in this plan, right? And I know John saw it first too, and he presented it to you, but there was an anchor within this that you could hang a hat on and move forward with, right? So
right. I mean the key thing with this debtor is that its number one customer was Amazon. So, when you see Amazon and you see the kind of business that is being generated from that one customer, and that one customer is not going anywhere anytime soon, and you see that kind of gross revenues coming in from that one customer, and you're looking at the income statement and the cash flows, and you're saying, but for these lenders, and the secured debt, this business would be humming along. So to me, that's what I zero in on is, putting aside the debt service, is this a moneymaker? And then it's just a matter of, okay, how do we restructure the debt? Because without it, they're able to make a profit, pay their employees, cover the operating expenses, so, they have something to reorganize. And that was the key here, with the debtor that John had. And, from my point of view, once you can spot, I call it the engine that runs. Once you can spot that engine, then everything else is virtually easy. The hardest part is when you look at the engine and it's not making money, and you have the principals. It's a small business. A lot of times it's family owned, and they just don't know when to pull the plug on it. And that's a tough case. But John's case, John's a extremely experienced bankruptcy attorney, and he knows to put a plan together fairly easy, fairly quickly. And then with me as sub 5 trustee, once I'm sold on that engine and the money making possibilities of it, I'm out there talking to the creditors, to the lenders, saying, hey, what's the alternative? I mean, it's better that you get paid, through the plan something than virtually nothing. So
this is the part that I was referring to, where the trustee and I almost create a partnership effort. It's not really a partnership effort, but that once he understands where you're coming from, what your plan looks like, how you're going to succeed, he's working with you to talk to the creditors to get them on board and cooperate. Right. And it's very helpful. It's not like a standard Chapter 11 at all. It's not an adversarial relationship whatsoever. It's very hand in hand, and that's what makes it flow. That's what makes it fly, because now you've got an officer of the court besides myself telling the creditors, this is the best it's going to get. This is where it's at. And right. So now you've got the trustee reaffirming that, because we're laying it right out on the table. That's what we have. So the results are dynamic, and the cooperative effort is dynamic. It has tremendous results.
And this is really what changed my perspective from a banker's perspective, right? It's the borrowers are greatly empowered here. They did not have this power before. They really do control this plan. They know what the plan is going to be. They're talking to professionals so they can see it. And the bankers really need to get on board and get cooperative as well. So that's this really is a great tool for businesses. It's going to keep some businesses alive and going. So awesome work. With that, I think we could open it up to questions. I'm sure we've got some great accounting professionals on here, and I think they could they could recognize these businesses and recognize a plan, recognize that engine within it. So they could certainly take it along a path before it even gets to you. But these are tough discussions, but we do want to open it up for questions if we have anything out there.
I don't have anything in the chat right now per se. I know, I just want to say, I know we've talked about this, but this is part of our, our role as CPAs is they're trusted advisors to, maybe not know how the inner workings are of things like this, but to know there's this option out there. We see their financial information frequently, hopefully several times a year. And I think this is great just to know that there is this option, having had clients that have gone through the other chapters of bankruptcy. So I have a question here. How does the PPP loan factor into the consideration of this type of bankruptcy?
Well, I had mentioned in our earlier version of this that originally the Small Business Administration had resisted making PPP loans to the new Subchapter 5. However, I think it was December 27th, the extension on the CARES Act was written in, and it specifically included the ability to do PPP loans, even for Subchapter 5 debtors.
Okay. We have another question. I know you aren't tax professionals, but to your knowledge, did you have any significant tax issues to consider or deal with in this particular case that you talked about?
The particular case at hand, we did not. They were current on their taxes, pretty smart about that. I think they were always very fearful of that. So we didn't have much to worry about. There are provisions that can be dealt with on tax issues, but it was not involved in this case whatsoever.
At the PPP, let's talk about the lending. Let's talk about, you mentioned SBA, and those that the SBA might not, but I'm thinking about small business lending. I'm thinking about the structure. So typically these small businesses, they get in there, and I think this was the case here. There was a second lien on somebody's house. John, talk through that. Talk through the guarantees. Talk through the second lien. So
that was not present in this particular case. Okay. But there is a provision for that if you, for instance, a lot of small business owners turn to their home for a line of credit to fund their business or to finance their business. In this case, they were using, we had 4 families full of credit card debt, 4 families full of line of credit debt, everything had been thrown into this. Of course, they had been in business for quite a while. That was another thing working in my belief that it was in their favor to try to salvage the company, because it wasn't that they didn't know how to run the company or didn't know how to do the trucking business. They obviously knew that. Their bookkeeping was in pretty good shape. They had computerized records and so forth. But as long as you can show, as Tarek had mentioned earlier, if that loan on that house can be shown to have been poured into the business, it was funded for the business. Those dollars went from the lender to the business account or to buy a piece of equipment or whatever it might have been. That individual can use this sub 5 the same way to strip off a mortgage on a house, much like, say, in a Chapter 13, if there's no equity in the house. In this case, even if there's an equity in the house, in the loan, they can still strip that particular note off in a personal bankruptcy as well. So they're eligible to file as an individual if they can show that it's business related debt.
Are there, John, are there any different rules in this type of bankruptcy versus another where I believe that generally the trustee deals with a hired forensic accountant to maybe work through some of the tracing of the money? In this type of bankruptcy, are those rules a little looser? And for example, are the existing CFOs or existing accountants able to do some of that work to help the client so it's not as expensive?
Well, yeah, you have to rely on what your clients provide to you. You have to stress to them how important accuracy is and so on and so forth. It can't just be guesswork. But yes, there can be a special cause for a trustee to want to call in an auditor or whatever else might happen. I try to make sure that our information is good from the get-go. I make a kind of a joke with my clients when they sit down. I ask them, I says, well, what's the difference between a tax planning and tax fraud as opposed to bankruptcy planning and bankruptcy fraud? Well, the difference is about 20 years. It gets the point across really well. and So that sets the stage for the game right from the get-go. You know, it's well received and it's well taken. So that's why I've not had that particular issue from very early on in my career. So.
We have another question. Although every case is unique, is there a cash flow income criteria level that a business must meet to fit into this subchapter 5 consideration?
Well, I'll refer back to Tarek on that. He's looking for that engine, and that's what we all are looking for, because if you can't have, if you can't reduce debt to a point to where you're producing positive cash flow or some kind of way of survival of the company, then it's time to fold the camp and go home. And that's what we're looking for in the first go round. In a case of this size, like I said, that first interview was about an hour and a half long, and many more hours beyond that once we decided this was worth looking at on a more serious level.
So Tarek, from your perspective on that question, right? So is it a one-to-one coverage that you're looking for? They've got to be able to service that. There has to be some kind of cushion, has to be some kind of growth that you're expecting this to be successful. There's got to be room to maneuver, right? What are you looking for there?
No, so I'm more mainly looking for positive cash flow over 3 years or 5 years, sufficient to cover the proposed plan, right? So as long as they're generating positive cash flow sufficient to cover the proposed plan payments, right? Then I'm good. What normally comes into play is when they want a reserve, you know, an operational reserve, and they want to fund that reserve, you know, with the positive cash flow. Then we start to get into this trading as to how much of a reserve do they need, and then what happens to the reserve at the end of the 3 years or the 5 years. So, you know, the growth potential, I'm not really focused on that much more than them being able to fulfill the plan obligations.
Survivability.
You know, yeah. Yeah.
There's no room for a cushion. You're not looking for a cushion, because that would be, you're able to act in excess of the plan. You're really looking for the plan, a one-to-one coverage on the plan.
Well, so yeah, so with me, you know, as long as it covers the plan payments, I'm fine. But you bring up a good point with the cushion, and normally the cushion is reflected in the in that what do you call it, capital reserve. Okay. Or operational reserve. And you know, I'm not one of those trustees who's looking at, oh, we need positive months. Every month needs to be a positive month. No, I mean, I'm looking at, you know, quarters, I'm looking at semi-annual, I'm looking at annual. It just depends on the cycle of the business. And you know, and that's tied into when they would make the payments to the creditors. You know, so as long as, you know, over that cycle, they're positive, because everybody knows some months you're going to be negative, some months you're going to be positive. But as long as they're averaging positives, you know, we're good, you know.
To add a little more perspective on that, the first thing I'm looking for is, what can I cut? What don't we need? What can I chop? And what will I have when I'm done with all of that? Now what do we need to now? What does that give us? Positive cash flow, or is there just no hope? And that's the get-go. That's all I'm looking for from the first hour. That's making sure that we've got survivability here, because if not, it's just a waste of time and energy.
Right.
And
a lot of times that's a hard conversation, because some of the principals, they want that raise, they want that bonus, they want to employ everybody in the family, and I understand that. But we're in a bankruptcy process, and for 3 years there's going to be sacrifice from everybody. You know, so the creditor is going to be sacrificing, the debtor is going to be sacrificing. So it's a process, and sometimes it's hard, you know, to explain that to the debtors, and sometimes it's hard to explain that to creditors who are not institutional creditors. For some reason, the banks are a lot easier to you know, convinced that, the projections are reasonable and they should, support the plan. Non-institutional lenders, when you have individuals who are lenders, it tends to be more difficult, because they're not viewing it they're not looking at just the figures. There's more involved for them, so it's a process. It's a small business, a lot of small business cases, and everybody knows it's people trying to make a living and, using their homes, second mortgages, and borrowing from family members. And, it's not going to be model accounting, and I'm not expecting perfect accounting, and then you're not, there are going to be months where the principal doesn't take a salary, and there's going to be a month where it looks like he took double salary. But that's a small business, so you just have to understand that. And back to Mari's point early on, I'm not a forensic accountant. I'm not charged with investigating the debtor or the financial affairs of the debtor unless somebody specifically asks the court to order me to do that, or unless the court orders me to do that. So, with a Chapter 7 trustee and a Chapter 11 trustee that's appointed, they have specific duties where they're free to go ahead and investigate away and look at avoidable transfers and all that stuff. I don't dig that deep. I look at what is presented in the schedules. I look at some support, and I look for disclosure. So if there was a transfer, classic repayment of family members or something like that, that ordinarily an aggressive creditor would want to pursue, from my point of view, and I believe some other Subchapter 5 trustees view it, is disclose it. Disclose it, put it in your plan, and at the end of the day, have the creditors vote. And with me, as long as it's disclosed, I can sell it. I can sell it to creditors because the business is reorganizes, the business is staying alive, and during that process, the creditors are getting paid. So why bother expend resources, attorney's fees, trying to pursue a repayment to a family member within a preference period, if you're going to get the benefit of that value anyway by keeping the debtor alive over 3-5 years.
That's well taken too. The other favorite saying is, this is a lot like, this is not like real estate. Real estate's location, location, location. Bankruptcy is disclosure, disclosure, disclosure.
Yep.
Without a doubt, beyond all.
I think that really emphasizes the cooperative nature of this too, right? And the lenders really do get on board here with the cooperativeness of it.
Yeah.
How about vendors, Tarek? You mentioned you didn't mention vendors in there. They're pretty cooperative.
So I mean, with vendors in normal Chapter 11, you got your critical vendors, and the debtors council will do their first day motions to take care of the critical vendors, and then you have the ones that are not crucial to the operations of the debtor. So it's a lot of times I see debtors council doing a good job at handling that. And then a lot of times, some debtors councils are not as thorough with that process. And the thing is, with any bankruptcy, you can't pay a pre-petition debt, that's owed to a vendor without court approval and showing that it's necessary to pay that vendor, because without that vendor, I'm not going to survive. And a lot of times where, they're trying to negotiate some kind of repayment and stuff like that, I'll get involved and, I'll show the vendor that you don't really need 100% of the 50 grand that you're owed. It's better to get, 25% now, and let's work something out, where you still supply the debtor on, COD or something like that. but they'll work on repaying the past due amounts pre-petition, because yes, they can't find somebody else to supply that part, you know, so we need you. So I would, you know, in certain cases get involved in on that front, because my goal is to keep the debtor operating and to get it to reorganize, you know. But a lot of times the debtors councils would have that already squared away, you know, because that's part of that should be part of your first day motions.
Mhm.
Yeah. Yeah.
And you've seen these worked on like 15 cases or so. Are there commonalities? Is there a variety? Are there just industries all over the place? Is there any kind of what should people be looking for?
Yeah. So there's, it's funny. It's a mix. It's a mix of cases. And I'm trying to see, you know, how, if there's any kind of cluster of cases. I thought I would be getting more restaurant cases. I haven't. You know, it's odd kind of businesses, you know, that the pandemic kind of took down. But there's no kind of commonality I can see, other than, you know, COVID-19.
Sure. Large receivables, heavy capital type stuff.
I think part of it for me, from my perspective, I'm looking for the high debt to asset ratio. That's going to be a key piece of it, especially if you're paying debt service on that high debt. Somehow you've got to bring the cost into line with what the income currently is. And under the COVID arrangement, with what's been going on there, nobody's got the cash flow. Very few have the cash flow they once had. And so now you have no choice but to look for where you can cut the cost of operations or cut debt service, one or the other. And that is most easily done where you have high loan to asset operations. That's why the first thing we did was go for appraisals on the four newest and biggest of the tractors, because we knew that there was way heavy debt load there. And as I pointed out, we saved this firm $7,000, roughly right around the $7,000. I don't remember the exact number, but it was right around $7,000 a month in debt service. That's a month in debt service. So obviously it's a high cost of entry type of business. I would say that's another. Restaurants are a high cost of entry type of business. For whatever reason, you don't see a lot of them filing Subchapter 5s yet, but I think Bill made a point earlier on about that a lot of people aren't even aware that it's out here. I don't think I don't think many non-bankruptcy attorneys are even aware of this newer subchapter to even point people in the direction. Maybe business attorneys might, as a subset, might be aware, but I think certainly bankruptcy touches all forms of the various legal patterns, including family law, because a lot of families break up over money. You know, there's all, and money is usually tied to a small business or a reduction in income one way or another. It's just that's just the way it's been with the COVID. I know, and I'm sure Tarek's aware too. They've actually talked about hiring more trustees and more judges because of the anticipation of the onslaught that is coming down the road at us. And there's been I serve on a couple of committees with Judge Isikoff and a couple of the other judges here in the Southern District, and there's been conversation there as well about worrying about how they're going to handle the onslaught, how they're going to handle what's coming down the road. So it's being given serious consideration, and I don't, like I said, I really I guess Durbin and Grassley's proposed legislation only carries through to the $7.5 million mark. I had heard at one point that they were trying to get it up to 10 million. But that is a massive amount of debt to be able to deal with, to be able to get into this program, and would cover a wide range of most small businesses. So,
Yeah, $7.5 million in debt, that's most businesses in this area. That's
Oh.
almost every business in this area.
Sure,
So
sure.
every locally owned
And
business.
it's a salvation for the, I mean, when the business goes down, the jobs go with it. And this is what I see as one of the most positive things. Now, granted, some small businesses never should have been started, and we can't say what isn't salvageable, but still, there's plenty of viable people out there that just things happen that we can't control sometimes. That's
Yes, they do. Yes, they do. Any more questions, Mary? I don't want to run out of time here with.
Yeah, there is one more, and it's if this applies to nonprofits. And I know you said that I wanted to mention too. I know you said this does not apply to real estate, and I know
single asset real estate. Now, if there's
okay, because I know a lot of nonprofits, if they do have debt, it's usually related to real estate. But does it apply to nonprofits?
It does apply to nonprofits as long as they're performing a service, even if it's nonprofit. There's actually a case, and I don't have it right in front of me, but it's already been decided that the nonprofits, as long as they can show a service that could otherwise be marketable or otherwise be used as a marketable service, yes, there are qualifiers, but yes. And
I was thinking that's
no reason to think most nonprofits wouldn't be in that category.
I think that was a homeowners association, John, and that would apply. If you think about many of the clubs around here that have been shut down for so long, it's
I think
probably
you're right.
applicable.
Yeah, I think you're right. You're absolutely right. That's exactly what it was. I couldn't remember exactly. Yes, it was a homeowners association.
Sure. And there's many medical related nonprofits. There's a lot of nonprofits that have, they've certainly been impacted, had to, all nonprofits probably have had the PPP and the staffing and everything else, right? So.
Right. I don't see any other questions unless anyone has one verbally. No? All right. Well, thank you all for speaking to us, and I don't know, maybe there'll be some kind of follow up if these laws or legislations get passed at the end of the month, and we'll see.
Yeah.
Yes, hopefully it will. It's,
Yep. Been very interesting. Glad to have been part of it.
All right, so like I said to everyone, if my email address is on the notice that went out for all of you that registered. So if anyone wants the slides, just shoot me an email. I'd be happy to send them over. And you should also get something from the FICPA to certify your attendance. Make sure you take care of that. Just check your account because we don't do it here at the chapter level anymore. And otherwise, thank you all. Have a great day and good luck with the rest of tax season, everybody.
Thank you.
See you on the other side of that. Thanks, everyone.
Everybody wants to be on the other side of that.
Thank you so much.